Good morning, friends. This week we will deal with the part 2 of the Constitution of India, which provides citizenship. Article 5 of the Constitution of India provides that citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and class A, who was born in the territory of India, or class B, either of whose parents was born in the territory of India, or C, who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be citizen of India. I submit to all the listeners that understanding of an enactment or constitution is understanding the words that are used in ordinary sense. This is the gospel of the truth in the construction of the any act or any constitution. So, what is the meaning of the words at the commencement of this constitution? To know the meaning of the words at the commencement of the constitution, we should refer to Article 6 also. Why? Because this article, that is Article 5 and Article 6 of the Constitution of India, apply to the question of citizenship at the commencement of the Constitution. These articles do not apply to the question of citizenship at the subsequent time. And also under Article 10 of the Constitution of India, a person who is citizen of India at the commencement of the Constitution of India shall be continued to be citizen of India subjected to the law made by the Parliament. So, for understanding at the commencement of the Constitution, which is mentioned in Article 5, Article 6 and Article 10, one must refer to Article 395 of the Constitution of India, which provides that 26th day of January 1950 is the day of the commencement of this Constitution. Though, in the same article provides that Articles 5, 6, 7, 8 and 9 and other articles mentioned therein came into force at once, which means on 26th day of November 1949. Please note that Articles 7 and 8 are not limited to their applicability to the question of citizenship at the commencement of this Constitution. So finally, at the commencement of the Constitution means 26th day of January 1950, though Article 5 came into force on 26th day of November 1949. In other words, every person who has domicile in the territory of India On 26th day of November 26th day of January 1950, shall be citizen of India, subjected to the provisions mentioned in Class A, Class B and Class C. And now, what is the meaning of the words every person? So, to understand the Constitution of India, Article 366 is a mini dictionary, and for that purpose Article 367 is also very important. Why? Because Article 367 empowers the General Clauses Act 1897 may be used for the interpretation of the Constitution. Then what is there in the General Clauses Act 1897? What section defines the word person? Section 3, subsection 42 of the General Clauses Act 1897 provides a person includes any company or association or body of individuals, whether incorporated or not. The same meaning we find in section 11 of the Indian Penal Code 1860. So, Class A and Class B of Article 5 shall refer to the natural person and not an artificial person, not to a legal person. Company is a legal person. Body of individuals is a legal person, whether they incorporated it, whether they registered or not. So, Class A of the Article 5 of the Constitution of India refers to a natural person, not a legal person, not an artificial person. So, the company cannot claim the rights under this article from the Constitution of India. Now the meaning of the word, what is meant by domicile? Why? Because at the commencement అనే పదానికి అర్థం తెలుసుకున్నాం, every person అనే పదానికి అర్థం తెలుసుకున్నాం, and who has his domicile కాబట్టి what is meant by the word domicile? Wharton in his law lexicon pointed out 2 points must concur to constitute domicile. One is residence and second is intention of making it the home for the party or a person. A place where a person ordinarily resides will not be necessarily his domicile. Residence and domicile are two perfectly distinct things, friends. But residence may be a small prima facie proof of domicile. Every person can at any time be without domicile. Ordinarily, a person can have only one domicile at one time. A domicile acquired is retained until it is changed. It is open to a person to acquire new domicile. On marriage, a woman acquires the domicile of her husband. And my dear friends, I request you all to refer section 15 and 16 of the Indian Succession Act 1925. Every company has a domicile. The domicile of origin of a company is the place where the company is registered. Then the meaning of the words in the territory of India. What is the word in the territory of India? Under Article 1, Class 3 of the Constitution of India, India shall comprise, what I mean, the territory of India shall comprise A. Territories of the states, B. The union territories as specified in the first schedule, See, such other territories as may be acquired. Now, the grittinity of the Article 5 of the Constitution of India is that every person who was born at the commencement of the Constitution is not a citizen of India as per Article 5. Every person who has a domicile in the territory of India and he must have born at the commencement of such Constitution, then only is the citizen of India. Under Clause B, every person whose either of his parents born in the territory of India and who was domiciled in the territory of India at the commencement of the Constitution is a citizen of India. To comprehend this clause, an exempli gratia is necessary. A child born to an Indian of an English woman in England and having domicile in India would be citizen of India. This is the simple illustration. Class C, every person who has his domicile in the territory of India at the commencement of the Constitution and who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement shall be citizen of India. Now, what is the meaning of the words ordinary resident? ఇక్కడ రెసిడెంట్ అనే పదం వాడలేదండి, ఆర్డినరీ రెసిడెంట్ అనే పదం వాడారు. ఆర్డినరీ రెసిడెంట్ ఈజ్ ఎ థింగ్ which can be changed in a day. Having one's domicile in a place and being ordinarily resident in a place are not identical. The meaning of the words residence and ordinary residents within their variations is often discussed in cases on income tax. Ordinary residence is contrast with usual or casual or occasional or temporary residence. I may be permitted to repeat once again. Ordinary residence is contrast with usual or casual or occasional or temporary residence. Ordinary residence is a residence in a place with some continuity. This is different from the temporary residence or accidental residence. For more comprehension, Section 20, Explanation 1 of the Code of Civil Procedure is pertinent. Where a person is permanent dwelling at one place and also temporary residence in another place, he shall be deemed to be resident in both places in respect of any cause of action under Section 20, Explanation 1. It is obvious that the meaning of the words ordinary resident cannot be the same as that conveyed by the words actually and voluntarily resides. These words are used in explanation 1 of the Section 20 of the CPC 1908. With this, we may conclude the discussion on Article 5 of the Constitution of India with a final illustration. An Englishman born in England, of parents born in England, shall be citizen of India if he had domicile in India at the commencement of the Constitution and if he was ordinarily resident of India for not less than 5 years before the commencement of the Constitution, shall be citizen of India. With this little discussion, we end Article 5 of the Constitution of India. Thank you so much. Thank you, friends. Thank you so much. India, that is Bharat, shall be union of states. The word union has been taken from the preamble to the British North American Act 1867. The word union has also been used in the preamble to the Constitution of United States of America. It may be noted that the word federation or confederation has not been used in the Constitution of America. The expression Union of States indicates that the Constitution is a federation, but it is not a federation based on the agreement among the units, and the component units cannot secede from it. As the preamble to the Constitution makes it clear, the Constitution is a creation of the people of India and not of the states. It is pertinent to repeat or reiterate once again this point is that the Constitution is the creation of the people of India and it is not the creation of the states. For that purpose, the states themselves being the creation of the people of India. In this connection, the position of the states under the Constitution of the United States of America may be referred to. Under the Constitution of the United States of America, the states shall have an independent existence. Okay, let us see one judgment of the Supreme Court of United States of America, that is County of the Lane versus the state of Oregon. The Supreme Court of United States of America held that the people of the United States constitute one nation under one government, and this government, within the scope of the powers with which it is vested, is supreme. What I mean is, the government is supreme. On the other hand, the people of each state compose a state. Let me repeat once again. On the other hand, the people of each state compose a state having its own government and endowed with all the functions essential to separate and independent existence. The states disunited might continue to exist without the states in the Union. There could be no such political body as the United States. This is what is held in County of Lane versus the state of Oregon in 1868 itself. It may be noted that in this connection, that originally India had a unitary constitution under which the provincial governments were practically the agents of the central government. Under the Government of India Act 1935, a federal system was established, but though the part relating to provincial autonomy was given effect to, the federation did not come into existence. In spite of the grant of the provincial autonomy, the provinces under the Government of India Act 1935 were not sovereign states, and they had no voice in the formation of the Union under the Constitution. It is again pertinent to repeat this sentence once again. In spite of the grant of the provincial autonomy, the provinces under the Government of India Act 1935 were not sovereign states, and they had no voice in the formation of the Union under the Constitution. Thus, the union of government under the Constitution is not based on the agreement among the states, which are component parts of the Union. The other features of the Union may be summarized as follows. Unlike the federal system contemplated by the Government of India Act 1935, there is a uniform political system for the whole country. There is a distinction in essential principles between the political system applicable to what were formerly British Indian provinces and Indian states. As already noticed, the government has been framed by the people of India for the people of India. The component units, namely the states, are what were previously the provinces and the Indian states, had as such no voice in framing the Constitution. In fact, the Constitution contains provisions both as to the Union as well as the component states. Consistently with the above features of the Constitution, it may be noted that the Constitution recognizes only one form of citizenship for the whole country and not a double citizenship, one for the states and another for the Union, as under the Constitution of United States of America. The national character of the Constitution is emphasized by the fact that the executive of the Union is empowered to give such directions to the states as may appear to it necessary for that purpose. Take for example Article 257. Similarly, under Article 258, there is a provision for the delegation to the state of executive power of the Union. The residuary power is vested in the Union under Article 248 of the Constitution of India. As under the Canadian Constitution and unlike the Constitution of the United States of America, there are similar provisions spread all over the Constitution. There is a provision even for the suspension of the state's authority by the central power in certain cases. For example, Article 356 and Article 365. Reference may also be made to Article 2, 3 and maybe 4 with the power of the Union. The Parliament to admit under Article 2 of the Constitution of India or establish new states under Article 3 of the Constitution of India, make changes with regard to the area or boundaries, etc. of the existing states. It may also be noted that there is no equality of representation of the states in the Council of States. I repeat once again, there is no equality of the representation of the states in the Council of States. At the same time, the component states are not mere administrative units or acting agents of the central government. Please do remember this. The component states are not mere administrative units or acting agents of the central government. In this connection, the observation of the Lord Watson in Maritime Bank of Canada versus New Brunswick in regard to the position of the provinces under the British North America Act in 1867 may be quoted. The object of the act was neither to weld the provinces into one nor to subordinate provincial government to the central authority, but to create a federal government in which they should all be represented, entrusted with an exclusive administration of affairs in which they had a common interest, each province retaining its independence and autonomy. These observations may be taken as fairly description of the position of the states under the Constitution of India also. Thus, the Constitution combines the features of the federalism as well as unitary system. The fact, the desire of the makers of the Constitution to establish a strong central authority is evident throughout the Constitution. In times of emergency, the federal government can be made into a unitary one. Yes, friends. Now let us see Article 8 of the Constitution of India, which provides the rights of citizenship of certain persons of Indian origin residing outside India. Notwithstanding anything in Article 5, any person who or either of his parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and who is originally residing in any country outside India as so defined shall be deemed to be citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing on an application made by him therefore to such diplomatic or consular representative whether before or after the commencement of this Constitution in the form and the manner prescribed by the Government of Dominion of India or the Government of India. Now, the effect of Article 8 is to relax in cases coming under the article the qualification that is prescribed under Article 5 of the Constitution of India. The following conditions must be satisfied for a person to be citizen of India under Article 8 of the Constitution of India. Firstly, he or either of his parents or any of the grandparents must have been born in India as defined in the Government of India Act 1935. Secondly, he must be ordinarily resident in the country outside India. He must have registered as, thirdly, he must have registered as a citizen of India. Fourthly, the registration must have been done by diplomatic or consular representative of India. Fifthly, the application must be made to such authority. Sixthly, the application may be made to such authority whether before or after the commencement of this constitution. The form of the application and the manner of making such application shall be prescribed by the Government of Dominion of India or the Government of India. If these conditions are satisfied, he will be entitled to be regarded as citizen of India under Article 8 of the Constitution. Friends, the provisions of this article is subjected to Article 9 of the Constitution of India, that is next article we are going to discuss. Any country outside India means what? These words shows that a resident of Pakistan is not outside the India and is not beneficial under this article. It may be noted that the words used are country outside India and not a foreign state. In this article, the words used resident outside India and the words foreign state is not used. Then any difference is there between these words? Certainly there is a difference. I remember and recollect at this juncture Article 367, Clause 3 of the Constitution. For the purpose of this Constitution, foreign state means any state other than India, and a proviso is annexed to this article, provided that subjected to the provisions of any law made by the Parliament, the President may by order declare any state not to be a foreign state for such purpose as may be prescribed in that order. Even a country which is thus declared not to be a foreign state will be a country outside India for the purpose of this article. So, certainly there is a difference between country outside India and a foreign state. With this little bit of explanation, I conclude Article 8 of the Constitution of India. Now, Article 10 of the Constitution of India. Continuance of the rights of citizenship. Every person who is or is deemed to be a citizen of India under any of the foregoing provisions of this part shall, subject to the provisions of any law that may be made by the Parliament, continue to be citizen of India. This article doesn't require much explanation or much discussion. Yes, friends, this article provides that every person who is deemed to be citizen of India under the foregoing articles, Article 5 to 9, will be continued to be citizen of India until and unless his status is affected by law passed by Parliament. The meaning of the word Parliament is found in Article 79 of the Constitution of India. And Parliament, law passed by Parliament, where is the power that is given to the Parliament to make law in this subject? Article 246 must be read with Schedule 7, List 1, Entry 17, which provides citizenship, naturalization and alien. So, the Parliament has power to make a law as to citizenship, not to any other states. We know that. Yes, friends. Now, Article 9 of the Constitution of India. Persons voluntarily acquiring citizenship of a foreign state not to be citizens. No person shall be a citizen of India by virtue of Article 5, or be deemed to be citizen of India by virtue of Article 6 or Article 8 if he has voluntarily acquired the citizenship of any foreign state. According to this article, even though a person must be citizen of India or might be deemed to be citizen of India under the foregoing articles, he will be ceased to be citizen of India if he has voluntarily acquired the citizenship of any foreign state. The emphasis is on the word voluntarily. And also I explained in detail what is meant by foreign state while discussing Article 8 of the Constitution of India. The word foreign state is defined under Article 367, Clause 3 of the Constitution of India. And whether he has become a citizen of a foreign state or not depends upon the law of that particular state. So, under this article, the Constitution Declaration as to Foreign States Order 1950 must be read and remembered, friends. Thank you. Good morning, friends. Today, we deal with Article 6 of the Constitution of India. Rights of citizenship of certain persons who have migrated to India from Pakistan. Yes, friends, because of the mass migration which took place on account of the division of the country into two separate states, it was found necessary to make a special provision with regard to such migrants. So, Article 6 and 7 are such special provisions. Article 5 provides the general rule as to citizenship of India, that is, citizenship at the commencement of the Constitution, whereas Article 6, 7, 8 and 9 are exception to the general rule that is enumerated in Article 5 of the Constitution of India. Article 6 and 7 are concerned with the migrants from and to Pakistan. These two articles make special provisions as regards such immigrants. Article 6 deals with the immigrants from Pakistan to India, whereas Article 7 deals with the immigrants from India to Pakistan. Article 6 deals with the question of immigrants from Pakistan to India. Now, with this little bit of introduction, we go to the main content of the Article 6 of the Constitution of India. Notwithstanding anything contained in Article 5, so despite of whatever said in the Article 5, a person who has been migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this Constitution if the conditions mentioned in Clause A, Clause B1 and Clause B2 are satisfied. Now, what is the meaning of the expression territory now included in the Pakistan? The meaning of this expression has been gathered from the Indian Independence Act, 1947. Under Section 2, Subsection 2 of the Indian Independence Act, the territories of Pakistan would be the following. 1. The territories which on 15th day of August 1947 were included in the provinces of East Bengal and West Bengal as constituted under Section 3 and 4 of the Indian Independence Act 1947. Secondly, the territories which at the date of passing the Act, namely 18th day of July 1947, were included in the province of Sindh and Chief Commissioner province of British Baluchistan. And thirdly, the territories included in what was previously Northwest Frontier Provinces. Article 5 states that there shall be a citizenship for every citizen if the conditions that are enumerated in clause A, B and C are satisfied. Whereas Article 6 provides that a person shall be deemed to be a citizen of India at the commencement of the Constitution if the conditions that are enumerated in Clause A, Clause B 1 and Clause B 2 are satisfied. Then what is the difference between shall be citizen of India as enumerated in Article 5 and shall be deemed to be citizen of India that is enumerated in Article 6? First and foremost, once a person is deemed to be citizen of India, his rights and obligations cannot be different from those of persons who is a citizen of India. And I don't want to answer this query, but draw the answer from the listeners simply by asking a small question that what is the difference between a son and an adopted son in the eye of law? There is no such difference. You all know this. We all know the meaning of the words at the commencement of this Constitution, as I explained the same in detail in the previous article, that is Article 5 of the Constitution of India. As per Article 394 of the Constitution of India, 26th day of January 1950 is the day on which the Constitution was commenced. So, notwithstanding anything contained in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of the Constitution is explained in detail. Now let us go to the Clause A to know the meanings that are enumerated in that Clause A. If he or either of his parents or any of the grandparents was born in India as defined in the Government of India Act 1935 as originally enacted. The meaning of the words, if he or either of his parents was born in India, needs no explanation. Whereas any of his grandparents was born in India means grandparents will include both maternal and paternal grandparents. Hence, the word any is used in Clause A. Then, the words India as defined in the Government of India Act 1935 as originally enacted needs some more clarification, some more explanation, dear friends. The definition of India contained in section 311, subsection 1 of the Government of India Act 1935, and such section runs as follows. British India. British India means all the territories for the time being comprised within the governor provinces and the chief commissioner provinces. And the next word, India, means a British India together of any Indian ruler under the sovereignty of His Majesty, all territories under the suzerainty of such Indian ruler, the tribal areas and any other territories which His Majesty in the council may from time to time, after ascertaining the views of the federal court and federal legislature, declare to be part of India. Then what is the meaning of the words tribal area? Tribal areas means areas along with the frontier of the Indian Balochistan, which are not part of the British India or of Burma or of any Indian state or of any foreign state. So the essence of section 311, subsection 1 of the Government of India Act 1935 is the India comprised the governor provinces, firstly, secondly, chief commissioner provinces, thirdly, Indian states, fourthly, tribal areas. So the conditions mentioned in clause A of the article 5 is not sufficient for a person deemed to be citizen of India, and conditions mentioned in clause B 1 or clause B2 must also be satisfied to a person deemed to be a citizen of India under Article 6 of the Constitution of India. Why? Because at the end of clause A, the word and is used. Now, clause B 1, in case where such person has so migrated before the 19th day of July 1948, he has been ordinarily resident in the territory of India since the date of his migration, then that person shall be deemed to be a citizen of India. Clause B1 contains two conditions, friends. Such person must have been migrated to India before the 19th day of July 1948. And another condition is, that is second condition is, he has been ordinarily resident in the territory of India since the date of his migration. Dear friends, I try to find out the import of the date, that is 19th day of July 1948. Dr. B.R. Ambedkar, the chairman of the Constituent Assembly, drafting committee, has stated that it is only a cut-off date. After clause A and clause B1 and clause B1 or is used, if the conditions that are specified in clause B1, that is, such person must have been migrated to India before the 19th day of July 1948, and secondly, he has been ordinarily resident of the territory of India since the date of his migration, is not satisfied. The second condition that is given under Article 6, Clause B2. Clause B2. So under Clause B2, where such person so migrated on or after 19th day of July 1948, he has to be registered as a citizen of India by making an application to the officer in charge appointed in that behalf. Then the form and the manner of making such application shall be prescribed by the government. But such application must be made before the commencement of the constitution, that is 26th day of January 1950. Next, a condition or proviso is added to the clause B2. Clause B2. The person making such an application must have been resident for 6 months prior to making such an application. సో ఈ ప్రొవిజియోలో రెసిడెంట్, ఐ మీన్ సచ్ పర్సన్ హూ ఈజ్ మేకింగ్ అన్ అప్లికేషన్ మస్ట్ హ్యావ్ బీన్ రెసిడెంట్. రెసిడెంట్ అనే పదం వాడారు తప్ప ఆర్డినరీ రెసిడెంట్ అనే పదం వాడలేదు అని లిజనర్స్ అందరూ గమనించగలరు. టోటల్లీ Article 6 provides that rights of citizenship of certain persons who have migrated to India from Pakistan and to get the citizenship, the conditions enumerated in clause A and clause B1 must be satisfied, or at least conditions enumerated in clause A and clause B2 must be satisfied. Unless these conditions are satisfied, a person cannot claim the citizenship under the Article 6 of the Constitution of India. Thank you, friends. Yes, friends, the last article in part 2 of the Constitution of India, that is Article 11, Parliament to regulate the rights of citizenship by law. Nothing in the foregoing provisions of this part shall derogate from the power of the Parliament to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. This means the Parliament alone has power to make a law as to acquisition of citizenship, termination of citizenship, and any other matter relating to citizenship. So it may be noted that subject of citizenship, naturalization and aliens falls exclusively within the legislative jurisdiction of the Parliament under Schedule 7, List 1, Entry 17. This I have already explained while discussing Article 10 of the Constitution of India. So, while exercising this power, the Citizenship Act 1955 was enacted, which contains 19 sections and 4 schedules. With this, we successfully completed the discussion on Part 2, the citizenship. Thank you, friends.